You ever wonder why you have all these text messages, emails, screenshots, and they never make it to the judge, or the judge sees them and still rules in the other party's favor? Stay tuned. Today, I'm going to talk to you about over documenting and over flooding the judge with your evidence. Why that's a bad thing. And welcome to Self-Represented in Family Court. So, here we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Hello there. It's me, Tracey B., and you're listening to Self-Represented in Family Court. Today, I wanted to talk to you about how you can be self-sabotaging when you're over presenting your evidence or over documenting things. You can actually do more harm to your case than you think by gathering tons of audio, email, text messages, and screenshots. If you have ever listened to me talk about gathering intel, I believe in gathering more than not enough, because sometimes you're only going to get one bite of the apple. But the way you gather this stuff can actually be disillusioning. It can give you this false sense of security. It can actually sabotage your case because you'll have all this evidence, all this documentation, all the intel that you think is going to work, make you think you have a slam dunk case. And yeah, I hear people, they've told me that a few times. Oh, the case is black and white. The case is a slam dunk. There is no such thing in family court. No case is a slam dunk. No case is black and white. No case is solid, 100% solid. Not in family court. Did you hear me? No case is solid, a slam dunk, black and white in family court. It just doesn't exist. It doesn't. If you're talking about a specific issue, a minor issue, maybe. But when you're talking about, oh, I know I'm going to get custody because I have this to prove that I am the more fit parent, that I am the one that deserves custody, that the other party does not deserve joint custody. I have everything I need. No, you don't have everything you need. I'm sorry. I know. You worked so hard. You spent so much time, gave so much effort to documenting things. You were writing notes, turning on the video camera, recording, taking screenshots. You kept all your text messages. You were smart enough to make them say what they've said in an argument in person, reiterate it in an email or a text message. You were diligent. You even have agreements in text messages where they agreed to something. You have pictures, video, social media where they admitted or somebody else admitted. You have all that. And kudos to you. Great job. But is any of it guaranteed? Is any of it helpful? Maybe. Is any of it harmful to your case? Maybe. Yep, you can actually set yourself up by having all of that. You know why? Number one, let's get to it. Number one, who's to say that you've gathered those things correctly or legally? Can you audio record the other party without their consent, without their knowledge, without their permission, and think you're going to present that in court? Can you videotape them legally without their permission, without their consent, without their knowledge, and present that in court? Can you take text messages and show the judge? Will the judge want to see these text messages? How about emails? Who's going to confirm or verify that this is an email that was not doctored, that was not made up? Nowadays, there are apps that will make an email thread appear as if it's a valid one. So now you've done all of this. How are you going to make sure that these are all in a legal or correct format to even make it past the opposing counsel? If the opposing party has an attorney, will it pass the muster of opposing counsel? Because if it doesn't, your judge may never see any of it. Opposing counsel, experienced ones, they know the legitimate ways to gather, to document, to present evidence. They know that. And if there are a way or several ways to question the legitimacy of what you documented, they're going to do that. Especially when you're pro se and you don't know the court rule that apply. When you don't know those things and you're thinking that just documenting is all you need to do, you're setting yourself up. Because all that time you were doing that, you probably could have been focusing on strengthening your argument, understanding the law, familiarizing yourself with the court rules of procedure, getting to know your judge, getting to understand the opposing counsel. That's what you probably could have spent your time best. But you didn't. Okay, so it got past opposing counsel. Opposing counsel is not objecting, is not creating any sort of noise with respect to how you gathered this documentation and how you're actually packaging it and presenting it. So it makes it to court. Now you're in court and the opposing counsel is not objecting to any of it. Okay, now the judge has to see it. Will the judge see it? Because just because the opposing counsel didn't raise any noise about it, the judge can decide that certain rule or law apply to it and makes it something they don't want to see. Or how about the judge just doesn't want to look at it anyway. Just not want, in the interest of time, in the interest of being efficient, just having discretion to decide what they want to hear or see. The judge never lays eyes or ears on exactly what you had presented to the court to substantiate your claims, to strengthen your argument, to support your case. So again, now you spent all this time preparing, documenting, and then what? You've gotten all this evidence. You've done exactly what people told you to do. You've done what you think makes sense. It makes sense to bring proof of your claims, your issues. It makes sense to bring proof to defend against the allegations of the other part. It makes a whole lot of sense, for sure. But if the judge never sees it, the judge never hears it, then now you've created this false sense of security, this false sense of having a slam dunk, black and white, solid case. Now you're in court and you're completely bare and vulnerable because you have nothing. Everything you thought you had is gone. Not only are you vulnerable because you have nothing to support your case, you have nothing to defend against the other parties. Now, the judge is looking at you like you lack credibility because you have nothing to support your position. If the judge doesn't see it, if the judge hasn't viewed it, heard it, it's the equivalent of having nothing. So now if the opposing party does, you just compromised your position. You see how dangerous that is? You see how that can set you up for a complete demise? Are you understanding how having evidence of following someone's advice to just document and gather this and that can be a false sense of security in your case? Because now you have nothing. Now you lack credibility because the judge is looking at you like, okay, you came in here with nothing. I'm supposed to believe your testimony. That's all you have is your testimony. Should the judge believe your testimony? You have nothing to support it, to back it up? Yes, Tracey, but I do have something. The judge just doesn't want to hear it or see it. That's the thing. That's my point. The judge has 100% discretion. Not you, not your lawyer, not the opposing counsel. The judge has 100% authority to decide what they're going to give attention to, what they are going to allow into evidence, what they are going to hear or see to help them make a decision or ruling. So you're there now. The judge decided, no, I don't want to hear or see anything you have. For whatever reason. And the reality is, if they do that and you think they're wrong, if it's not an official hearing, meaning they're not making a ruling on the record, your recourse is very limited. So it's important to understand how important it is to be strategic about what you're documenting and how you're presenting it. You can have mounds of evidence and proof and documentation. It may not matter if a judge never lays eyes or ears on it. And that's what you're up against. So if you know that as you're documenting, you may position yourself differently. You may position what you have differently. You may position your argument differently. You should. Because if the judge ignores it and decides to listen to your testimony and believes that you're not credible, they're not going to believe you, the judge is going to make a ruling in the other party's favor. Now, the issue that you have is your child's safety. You have legitimate concerns about your child's safety or well-being, and you just blew your chance. So now the judge is going to make a ruling in favor of the other party that puts your child in even more jeopardy, at risk of harm or compromise of their safety or well-being. You see how that is self-sabotaging? You can't take that chance. You can't, because once the judge makes that ruling, you might be stuck with it. So now you think you were worried before. Now you're really worried. You're angry. You're disappointed. You're frustrated. You're disgusted. You're all of that. And guess what? Nothing has changed. The judge issued their ruling and nothing has changed. All because you documented, but it meant nothing in the end. Your evidence didn't pass the muster. It just didn't. Okay, so now, all right, Tracey, Now I understand. So now when I go back, I'm going to present my evidence in a much better way. I'm going to gather it in a much more strategic way. And I'm going to get the judge to see it and hear it next time. You know what the problem with that is? When is that next time going to be? Because you can't re-argue the same issues. It depends on the dynamic. It depends on the stage of your case. Maybe you can. But if it's an issue the judge already decided on, you can't bring the same issues with the same facts and the same claims and defenses the next time you go to court just because you think the judge made an error because they didn't allow your evidence in, and now this is your opportunity. It doesn't work like that. So you see how people think having solid evidence, having tons of it, is one surefire way to ensure that, okay, you have 20 different pieces of evidence. Okay, 5 of them won't get in. Maybe 10. But I have 10 other ones, Tracey. But suppose those 10 other pieces of evidence are not really strongly correlated to the issues the judge has to make a decision or ruling on. The 10 pieces that were the strongest, closely correlated to the issues the judge has to make a ruling on, those are the ones that the judge doesn't want to hear because maybe you got them incorrectly, you presented them incorrectly. Judge, wait a minute, don't ignore those. Those are the strongest ones. You're looking at the wrong ones. You're looking at the ones that are not the strongest. You can't say that. That's not how it works. You have to be strategic. A lot of you are taking chances with just listening to other people say, all you have to do is show this. Bring this to court and it's a slam dunk. Bring this to court and there's no way the judge is going to rule in the other party's favor. Bring this and it'll shut the other party down. It doesn't work like that. It's not how it works. How does it work, Tracey? Be strategic about what you document, how you document, mainly how you present it to the opposing counsel, but definitely how you present it to the judge. Is your judge the type of person that's interested in listening to audio? Will they ignore the fact that the audio is not presented in the correct way? Will they ignore any objection the opposing counsel might make because the issues are so important, that these issues are so important to your judge that the judge is probably going to want to hear or see what you have? These are some of the questions you need to be asking yourself. I see so many people who think they have it in the bag because they listened to other people and heard what worked in their case, disregarding the fact that their judge, their jurisdiction was entirely different. The circumstances, the dynamics was entirely different, ignoring that. Just assuming because the law says this is what the factors are, and this is what I know is going to support every factor that's stated in the law, I know I got a slam dunk case. It doesn't work that way. It's not just the law. It's the rules of procedure. It's your judge. It's the dynamics. It's the background. It's all of that. So when you're documenting, first of all, I say document strategically. Before you actually present it, be sure you know what you are intending to do and the outcome. Ensure that you know who your judge is, what your judge cares about, how your judge applies the rules, how your judge sees the law. Those are the steps between your intention and the overall objective, your overall outcome that you're pursuing. Those things should not be overlooked. I ask people often when they say to me, hey, should I tell the judge this? Should I show the judge this? I always ask them, for what? And they'll be like, oh, because the other party said this and said that, and I just want the judge to know. For what? Why do you want the judge to know that? What's your goal? Oh, I would think the judge would want to know. You shouldn't be thinking anything about your judge. You should know. You should not be guessing what your judge cares about. By the third appearance before your judge, you should know what they care about. No more thinking and guessing. No more listening to other people tell you what you need to show the judge. Stop that. That is self-sabotage. Stop it. That's not how it works. Find out what your judge cares about. Find out what your judge listens to. Find out what moves your judge. Then you'll answer your own question. Should I show the judge this? My judge is the kind of judge that doesn't really care about those things because they're just not that type of judge. They happen to be more of the letter of the law kind of judge than they are about understanding circumstances. Ask yourself. If you don't know your judge, get to know your judge. If you don't know the opposing counsel, get to know the opposing counsel. Every time the opposing party changes counsel, get to know them too. Get to know the guardian ad litem. Get to know the key players. Stop guessing. Stop expecting other people to answer those questions for you. Answer them for yourself. You're not going to get it. And when the case goes the way you don't, and you're upset because the judge ignored your concerns, blame yourself. Blame yourself. Not the other party, not the opposing counsel. Blame yourself. I'm telling you how you increase the chances of the judge actually listening to you, your evidence, and your claim, and believing what you're presenting to them. I'm giving it to you. If you don't understand, let's talk. We can go over it. Let's have a discussion. The issues you want to know if what you plan on presenting to the judge to support those issues, to strengthen your argument, to actually position yourself, your issue, your case to your advantage. Let's talk. Let's have a meeting. I can't give you legal advice, but I can tell you strategically what you can do to position your case so that the judge is more inclined to hear and see your evidence to support your claim, to find you more credible, to make you more, quote unquote, likable and more favored by the judge. Let's have a meeting. I will explain to you. Within the first 15 minutes, I assure you, I will highlight, identify, assess whatever the issues are, the bottlenecks you're facing that's causing you or your judge to not see or believe what you've been presenting to them. That's what I do in my strategy session. So, if you've been in a position where you had all this good, strong evidence, and you just couldn't get the judge to hear it or see it or accept it, you probably need to go back, regroup, and start implementing some of what I said in the last few minutes. If you need help, that's what I'm here for. I can help you. That's all I have for today. Hopefully this was helpful to any one of you. If you'd like to schedule a strategy session to discuss how to present, how to document the court rules of procedure, how to talk to your judge, and any of the key players, please feel free to schedule a strategy session with me. They're an hour, and they range from $250 up to $700, depending on exactly what we're going to focus on. I assure you, you will have at least 3 aha moments once we're done. And you will most likely be inclined to set up a month, 3-month, or 6-month consultation package where we meet regularly and we discuss strategy and we develop a case map for your case. You don't want to do all of that just yet? Just do a strategy session. That's it. That's all I have for you today. Until next time, thank you so much for listening. I appreciate you. Take care. We want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.